striving to be compliant with what has become known as the Cookie Directive, the 2011 Electronic Communications Regulation, and obviously in combination with the consent obligations that we all know and love from the GDPR. With the looming deadline of the 5th of October, it was with some optimism, I guess, that we reached out to the Office of the Commissioner no more than about 10 days ago, asking if it might be possible for some clarification, or at least for representation from the Commissioner's office to link with us for an event like this and to provide some clarification on key elements of the cookie guidance that had been issued, I think most recently back in April of this year. As always in Ireland, when you have 6 or 8 months to play with, people really only start to take notice once they're back from their holidays and in the final 3 to 4 weeks. Helpfully, the Commissioner has given us those deadlines more recently on LinkedIn to let us know that the clock is ticking. And you can appreciate then that we were absolutely delighted at the positive and constructive response from the Office of the Commissioner, to which Tony Delaney, the Assistant or Deputy Data Protection Commissioner and the Head of Regulatory Activity, as well as Elaine Edwards, from the Special Investigations Unit, kindly made themselves available at such short notice to participate and contribute to today's event. As John quite rightly said, without further ado, I'll hand over to our 2 speakers today, and John will facilitate the movement through the slide deck. And I look forward to your questions at the end. We have some preemptive questions ahead of time, but obviously if anything that's said or maybe even not said over the course of the next 40 odd minutes triggers a question for you, please do avail of the chat facility on your screens to flag those questions, and we'll make every effort to raise the questions with Tony and Elaine as time permits. Thanks very much, and Tony, if I can hand over to yourself to kick off the presentation. Thank you.
Thank you very much, Hugh, and thank you, John, for the introductions. Firstly, we're delighted to be here, and it's a great pleasure to speak to your audience today. Thank you very much for the invitation a couple of weeks ago. It's in everybody's interest that the message is clear, so any interested audience is always something that interests us, and we're delighted to speak to you today. So I'm going to move then through the slides. So the first slide is the background to the cookie sweep, and I suppose the opening point to say is that the Data Protection Commissioner, the DPC, is the national authority in Ireland responsible for the enforcement of the law in relation to e-privacy. We hear all about GDPR all the time, I suppose, but e-privacy is a very important aspect as well. It's one of the other responsibilities that we have. So in that context then, last August of 2019, we did decide to do a cookie sweep by issuing a detailed questionnaire, and Elaine will be talking in more detail about that. And the reason for doing it is we wanted to examine compliance with Regulation 5 of the e-privacy regulations, and that's in a statutory instrument of 336 of 2011, which implements Article 5 of the e-privacy directive. I suppose the thing to say in terms of the background really is why we embarked on this in 2019, and I'll just fill you in on some details on that, because several factors came together, I suppose, in the summer of last year. Firstly, GDPR had been in effect for about a year, since May of 2018. And then during the summer of last year, there was a couple of CJEU judgments either out or on the way out. One was in July, the Fashion ID judgment, and imminent in the summer of last year, and it eventually came out in October of 2019, was the Planet 49 judgment. So we were aware of all those things dovetailing. Then, as well as that, as staff of the DPC, we ourselves obviously use websites regularly, and we had our own observations in relation to cookies and cookie banners and so on that was somewhat troubling us. Coupled with that then, complaint levels from members of the public have increased. So I suppose partly to do with greater awareness around data protection generally since 2018 and the GDPR, and you can imagine that people, generally speaking, within the population are far more attuned, shall I say, to data protection nowadays and to personal data issues, particularly since there was so much publicity around GDPR. So people have begun to look at cookies, and people who are interested in privacy in particular are keen to complain to us when they see matters that trouble them, be it on websites or anywhere else. So again, website complaint levels were increasing a little bit, I suppose, as well last year. And then in the summer of last year, I was in the fortunate position that I was appointed as a Deputy Commissioner and the Head of Regulatory Activity at the DPC. I've been working at the DPC since 2006 as an assistant commissioner, but when I was appointed last summertime to this new position in the office, clearly I had to come up with strategies and ideas for what I was going to embark on this new role that was created, and to sit down with the commissioner and talk about things that needed to be done. And obviously one of the things that it was on my mind for some time as well was enforcing the law in relation to cookies, because I was around in 2011 when, as Hugh mentioned, the law, this SI came into play on the 1st of July of 2011, but it wasn't, we didn't have the resources, I suppose, to actively pursue this whole area in terms of cookies. So again, that's the other point. We did, as an office, start to get considerable new resources in the last few years. We've gone up from a staff of around 28 or 29 in 2014, before Helen Dixon came along, and we now have over 140 staff. So we do now have the resources to deploy to projects like this. And as I say, this was one project then in the summer of last year that I was keen to get started along with the Commissioner. And my background is as an investigator, and I'm obviously involved in enforcing and involved in prosecutions at the DPC as well. But it's important to point out to the audience today that Elaine and myself, neither of us are lawyers, neither of us are technologists, but we're certainly investigators, and we certainly are capable of doing prosecutions and enforcement work. And this will be the route that this particular project will take eventually once we get past the deadline that we'll talk about later on. So that's part of the background. And just to say then, in relation to the regulation itself then, the regulations that I spoke about, SI 336, they protect privacy in electronic communications, including the storage of information and access to information already stored on computers and devices. So when we got embarked on the sweep, we were seeking to examine how data controllers obtain the consent of users for the deployment of cookies and tracking technologies on their websites. And consent now is at the GDPR standard. And this is why this is so important, that standard is, since 2018, the consent in terms of data processing. It's highlighted there: freely given, specific, informed, and unambiguous. And that's quite a high bar. So that's why it's important that the application of consent in terms of cookies must meet that standard. And that's what we were looking into in particular, to see how is that being achieved. So our sweep was tackling that particular issues. So we chose a number of data controllers across a range of sectors: banking, insurance, retail, sport and leisure, media and publishing, restaurants and the public sector. And we chose them really on the basis of the popularity of the websites, based on our own observations, obviously, and in some cases based on complaints from members of the public. So that's generally the background to the sweep. And I'll move on now to the next slide, which talks about the law. And again, as I said, the Irish e-privacy regulations, as we call them, they were implemented by the statutory instrument 336 of 2011. But that is a separate instrument. It's important to be aware that that is a completely separate instrument to the GDPR, but it complements the GDPR. So organizations must comply with both laws, but the rules under the e-privacy legislation apply first when you're considering your organization's use of cookies and other tracking technologies. And Regulation 5 is the one that's the important one for what we're speaking about today. Regulation 5 of the e-privacy regulations is the relevant legislation regulating the use of cookies. And the law is set out there on the slide, Regulation 5.3. A person shall not use an electronic communications network to store information or to gain access to information already stored in the terminal equipment of a subscriber or user unless, and the first one is, A, the subscriber or user has given his or her consent to that use, and B, the subscriber or user has been provided with clear and comprehensive information in accordance with the Data Protection Act, which is both prominently displayed and easily accessible, and includes without limitation the purposes of the processing of the information. So really that's the law, that's the statutory part of the regulation that one must comply to in practice. So the purpose of the law on cookies is to protect individuals from having information placed on their devices or accessed on their devices without their consent that may interfere with the confidentiality of the communications. That's what it is there in a nutshell. And then we'll move on to the next slide, which deals with the exemptions. And there are 2 exemptions. So Regulation 5.5 sets out the criteria a cookie or other tracking technology must meet in order to be exempt from the requirement to obtain consent. So the first one is the communication exemption. And the communication exemption applies to cookies whose sole purpose is for carrying out the transmission of a communication over a network. For example, to identify the communication endpoints. It may also apply to cookies used to allow data items to be exchanged in their intended order, such as by numbering data packets. And it also applies to cookies used to detect transmission errors or data loss. So from the example we've given in our guidance note is for a communication exemption, the example we've given is a load balancing cookie used to distribute network traffic across different servers. The second exemption then is the strictly necessary exemption. And a cookie that is exempt under this criterion must simultaneously pass 2 tests. So the first test is it applies to information society services, that is a service delivered over the internet, such as a website or an app. And in addition, the second part is that the service must have been explicitly requested by the user, and the use of the cookie must be restricted to what is strictly necessary to provide that service. So again, from our guidance note, an example that we give of a cookie that meets the criteria for the strictly necessary exemption is a session cookie used to keep track of items that the user places in an online shopping basket. And these cookies expire at the end of the session or shortly thereafter. So that's the 2 exemptions. At this point now, we'll go on to the next slide. And Elaine, I'm going to introduce Elaine Edwards. Elaine will speak to you on the next number of slides. Elaine is the principal investigator who conducted the sweep in our office last year. She's also the author of the sweep report that we published on the 6th of April, and she's the author of the guidance note on cookies and other tracking technologies. So Elaine joined the Data Protection Commission in early 2019, and we're very fortunate that she did so. And she is our resident expert now at this stage on all matters cookies related. So I'm delighted to hand over now to Elaine for the next few slides. Thank you.
Thanks, Tony, and thanks, John and Hugh. Thanks for the invitation today to speak to you and to the people participating on the webinar. Just to follow on from what Tony was saying, when we commenced this project last August, which seems like a very long time ago now, and it's over a year ago, this was always going to be a very significant body of work for the DPC in terms of our regulatory activity. And the project itself at the outset did proved to be a major body of work for us, but it continues to be a significant part of our activity in the Special Investigations Unit with myself and my colleagues on a daily basis. So this project is ongoing. At the outset in August of last year, we set out, we listed 40 controllers to send out a questionnaire at the outset to them around their practices in relation to cookies and other tracking technologies. The report and the guidance note, as you're aware, are published on our website, but we can certainly get a copy sent over to anyone who needs it. But all the questions that we set out to the controllers are in the back of that report, so you can see what it was that we were attempting to interrogate at the outset. So we got 38 responses back from those controllers across that range of sectors that Tony outlined for you there earlier. We essentially gave one controller a reprieve, and they didn't actually complete the questionnaire because they were just on the verge of launching a new website at the time. So we felt it was probably pointless to begin an examination of a website that was about to be deprecated. So there was one controller that didn't respond to us, and as we've said on a number of webinars, that non-response or non-cooperation is not an approach that we would recommend controllers take with us. So when we assessed the responses, essentially it is set out in the report here. This was not a very technical examination at the outset. We were looking at a very high level at the transparency issues, I think in particular at the presentation of information to users of websites in particular. And it's important to note that we just examined the websites in particular on browser, in a browser kind of environment. We weren't looking at apps for this particular exercise, although obviously our guidance will cover all of the technologies that involve the use of cookies and tracking technologies. So when we assess the submissions and the websites of the controllers involved, we found that 10 of the controllers who responded to us were deploying pre-checked boxes or sliders, which were obviously not compliant with the law, having regard to the Planet 49 judgment of the Court of Justice of the European Union, which was delivered shortly after our sweep commenced, in fact. But that clarified that the use of pre-checked boxes cannot be used to constitute valid consent for the use of cookies or tracking technologies. So quite a lot of controllers also, 2/3 of them who responded, were relying on the use of implied consent, which will probably be a familiar term to most of your audience. Again, it probably wasn't a huge surprise to us, but the deployment of banners in particular, you would see wording such as, by continuing to use this website, you agree to our use of cookies, and click OK, got it, or whatever that might be. Now that is in effect taking that the user has given consent just by the fact that they are continuing to use your product or service, and that is not valid consent. Of the controllers who responded, again, just under 1/3 of them, we think, had already identified improvements that they could make to their websites. It was good to see this kind of response coming back to us, because it was clear that some controllers were already aware really that there were probably issues around their deployment of cookies and tracking technologies and how they were presenting information to users, to customers, to people coming to their websites. And all of them as well were very keen to obtain our updated guidance, which we have obviously now provided, but it had been some time since we had provided guidance in relation to the use of cookies. So we're very glad to be able to provide that to controllers now. And I'll move on to the next slide there, John. Okay, I did mention there in the last slide that use of implied consent. So we did see that the implied consent model actually also encompassed the kind of scrolling activity where somebody would just possibly see a banner flash up on the screen on the landing page, and then that banner would disappear shortly after the person either maybe touched a mouse wheel or just began to scroll. So that's fairly common, but again, sometimes you might even just see the banner just about would have a wording to say, by using this website you consent to use of cookies, and then lo and behold, it's just disappeared. The other issue, I suppose, was badly designed or barely visible banners or very poor presentation of information. So that would be the case where there might be a tiny banner across the bottom or the top of the screen, which was designed in such a way that perhaps the color scheme blended into the interface in such a way that you might not even realize it was there until it had disappeared, or that it just didn't disappear off the screen at all. So that's poor practice, because it isn't providing adequate transparency to users when they come to your website. The information should be clear and it should be visible to them. A major issue, and it's one that will be a major part of our enforcement activity, I suppose, was the the setting of non-exempt cookies, including a lot of advertising tracking on some sites without consent. And when I say without consent, I mean that these were actually set on landing on the first load when a user would come to the home page or whatever page they're redirected to from a link or whatever. So you could see in the browser activity that a lot of cookies and trackers, analytics and so on had been set without consent, even though perhaps in some cases there was a banner in place saying you can consent to the use of cookies, or you can, refuse cookies. In fact, the banner in effect was worthless and useless because the activity was already going on in the browser behind the scenes. So that was actually very common. And again, as I mentioned, the pre-checked boxes or sliders, this applied probably in the case of some controllers using a third-party consent management provider. There were several different ones in use. I think probably 3 or 4 commercial products. But again, this was really, I suppose, about how the particular controllers had decided to deploy this tool. And it was clear in some cases that the boxes were pre-checked, but it was also clear to us in the case of some websites that even if we unchecked those boxes and continued our activity on the website, that the cookies were being set anyway. So the tool, it was an illusory sort of tool that was there, essentially a cosmetic device that was maybe in a misleading kind of fashion, allowing people to believe that they were being given a real choice to allow particular cookies or to reject them. So that's something that we'll be looking at again in future activities. There was a lack of clarity in a lot of cases around how consent for the use of cookies can be withdrawn. And I think this is possibly, it's a design issue, it's an interface issue, I suppose it's an issue around how you manage your website and how it's designed, and about the difficulty maybe of presenting clear information about what's going on under the bonnet perhaps. But it should be clear to users when they come to your website or to your app that if you consent to this today, you have a clear means of withdrawing your consent tomorrow or in 6 months' time, and this is how you do it. So that can be done in different ways. Again, I think it's probably effective, and we've seen that it's effective on some websites to use perhaps something like a radio button that can be used just to kind of pull up the cookie consent management tool at any point, so that somebody can decide they want to turn off analytics, for example. So we also saw a lot of controllers referring users to their browser settings to direct them in how to manage their cookies and how to delete cookies and so on. Again, it's quite clear that you can't really infer consent. You can't infer consent for setting cookies by means of the default browser settings. And even though a number of browsers, the main commercial browsers now, do appear to disable the deployment of third-party cookies by default, a controller can't assume that a user or a consumer has purchased or has acquired a browser that by default has third-party cookies turned off. So there should be a means of control at the outset for the user when they come to your website. The other issue is the nudging kind of design, in the sense that there's an awful lot of accept buttons which are prominently in red or green, with manage settings or reject buttons grayed out or not as clear, even if they're the same size, but it appears to prompt the user into clicking the accept cookies by default. And that is a kind of a nudging design that really is not transparent enough, and we wouldn't consider that to be transparent or compliant. I'll move on to the next slide there, John. Other issues of concern to us when we examined these particular controllers' websites was, I suppose, in the health sector in particular, and this would include both commercial and, in some cases, public sector organisations, that there were advertising trackers such as DoubleClick and so on being deployed. And our concern there is that where somebody is using one of these sites and where there are perhaps other tools deployed, maybe tools that are recording people's activity on the site, the pages they visit, the search terms they input and so on, that there is the potential here for special category data to be captured and to be sent to third-party advertising, to advertising businesses and so on. Again, that would be a concern, because people could be targeted with advertising on the basis of health conditions or special category data. And, I think some clarity is needed on that. And this could potentially be an issue, I suppose, where a particular controller might have a website or a portal that people can use to log in to a customer account, for example. So where there's any kind of processing of personal data going on, where it's clear that there's processing of personal data as well, we would certainly be keen to know what else is going on in terms of tracking of users and in terms of what data is being passed to third parties there. And again, it's worth mentioning now, I suppose, and it's clear from the Planet 49 judgment that the use of cookies and tracking technologies doesn't always involve the use of personal data. A cookie itself doesn't necessarily, it doesn't necessarily have to be personal data, although I suppose the allocation of unique identifiers and so on to a particular individual can be personal data in itself. But certainly where personal data is processed as a result of an organization's use of cookies and tracking technologies, we will be very keen to know what's going on under the surface there. And do bear in mind that all of that is subject to all the data protection principles and to the provisions of the GDPR, etc. So there was also inadequate information came back to us, I think, from some controllers about their use of the likes of pixel technologies. Now, we can obviously see that certain pixels are deployed. You can use certain tools to see that there's Facebook pixels, etc. I think in some cases, controllers genuinely just didn't know that they were there. They didn't know that they were using them. And partly that can be because they've maybe outsourced their website service and their hosting, etc., to a third party. They don't necessarily have ownership or think that they have ownership of what's going on behind the scenes or under the bonnet on their website. We saw also cookies with extremely long lifespans, and I think in recent weeks, as I've gone back to look at some of the websites, some of these have been addressed or they've been removed, but we certainly can't see any reason to have a cookie that would have a lifespan of 100 years and even longer without any clarity as to what the purpose is. There are certainly an awful lot of cookies that are being deployed that where we couldn't immediately determine the functionality. So controllers are going to have to be alert to what's on their sites and what's going on under the surface, and whether cookies have been deployed that may now be obsolete or that they may need to remove. There was also some awareness from some controllers about the Fashion ID judgment, which was delivered in July of last year, the Court of Justice judgment there in relation to joint controllership issues. And I think this is probably one that, for smaller controllers in particular, they might want to take into account is, some controllers I think are not going to necessarily want to find themselves in a position of being in inadvertent joint controllership position with a very large social media company, for example. But it does seem to be the case that if controllers are making this decision to deploy particular particular embeds and so on, or buttons and social media tools, that it could very well put them in the position of being a controller in respect of personal data that they obtain and pass to that third party, although they're not a controller in respect obviously of what that third party then subsequently does down the chain. There was some confusion also between the e-privacy regulations of 2011, the statutory instrument, and the EU's proposed e-privacy regulation as it then was, which, again, as most of you will know, is not enacted and will, I think, be some way down the line in any case, if anything is agreed. Again, the quality of information provided on websites around cookies and the identity of the controllers was actually another issue. And again, do bear in mind that controllers are obliged, the transparency provisions of the GDPR also do require you to provide this information, such as the controller's identity and so on, and how they may be contacted, how data subjects can exercise their rights, and those provisions are set out in Article 13 and 14 of the GDPR. I'll move on to the next slide. We do get asked a lot following this exercise, can we point to the best examples of what a cookie banner should look like? How can we be compliant? And the answer is we actually didn't really come across any extremely good examples in the course of this exercise of how information on cookies was presented and how banners, etc., and consent management tools were deployed. And we didn't expect to because, as we had said earlier, we know that our own guidance had not been updated for some some time. So certain practices had probably just become the default, and probably a lot of controllers just follow what other controllers are doing. And so the implied consent issue, for example, while it might previously have been considered the norm and considered compliant, that very clearly is not the case now. So we do view this now as a good opportunity for controllers to bring themselves into compliance, to examine our report and our guidance, and to start working with their teams, I suppose, and to audit their use of cookies and tracking technologies, to see exactly what they're doing. That might involve privacy teams, DPOs, senior management, etc. So this is a good opportunity for controllers to begin doing this now. We're not going to be prescriptive, I think, about how controllers design their cookie banners or what consent management tools they use, whether they decide to use something in-house or whether they use a third-party provider. And again, this is a question we get a lot: is what should our cookie banner look like? And we can't really tell you, other than on a case-by-case basis, when we look at your product and if we think that this is not sufficiently transparent, that it is not providing adequate information about all the purposes of the processing, that it is nudging users into accepting cookies by default, that it is perhaps bundling consent for multiple purposes that aren't clear, if there's no way of people withdrawing their consent, that all has to be factored in to a controller's design decisions, to the policy decisions, I suppose, they will make in many cases, and controllers just will need to sit down and work that out for themselves. And what is going to be appropriate for your product, what level of transparency is required, might depend on the kinds of cookies and tracking that you're using. Certainly I've seen some public bodies, and I have mentioned these in other webinars. If you look at the EDPS and the EDPB websites, they deploy banners which are they're very clean, with kind of 3 options, and they do have that accept all, reject all, and manage options buttons, all given equal prominence. Now, again, I think in those cases, a lot of these organizations aren't doing a lot of analytics. They might do some analytics, but you are permitted to opt into those, and there isn't a lot of advertising tracking going on in the background. So we do see that this will be, it'll be a different challenge for different organizations and for different controllers, depending on the products and services that they are providing. So I think I've gone through that these options are there for you. There are multiple different ways of deploying these tools, I suppose, and what we just really don't want to see is that something is deployed in a potentially misleading way for users. That'll be key for us, I think, going forward. I'll move on to the next slide there, John. So our next steps are as follows. Well, what we did in April, we published the guidance on the 6th of April along with the report, and that was immediately distributed to all the controllers who had participated. Now again, we have been asked by some controllers, what rating did we get? We used when we were doing this exercise internally, we set a kind of a red, amber, green rating for controllers. Now, we didn't give controllers an individual report about their grading as such, because we don't typically go back to controllers following these exercises to give them individualized reports. This was designed as an overall compliance exercise, and it was designed so that we could actually produce our new guidance for controllers and go back to them and say, this is what controllers need to do now. But we have actually engaged with some controllers. They've come back to us with questions and so on, of those who participated in the sweep, and we have had conversations with some of them on the phone to answer questions that they may have. This report and guidance have also been distributed fairly widely, as Tony mentioned there earlier, to compliance organizations, to business organizations, etc., and to our DPO network, which is, I think, now over 1,900 DPOs in our network. It's also been distributed to public and private sector bodies. So we hope that most controllers that this will have implications for should be well aware of it by this stage. We produced a podcast of our own to highlight the outcomes of the sweep, and Tony and I'd say at this stage we're upwards of maybe 10 or 12 different webinars between us, reaching out to various organizations both in Ireland and overseas to discuss the report and the guidance. So our team within the Special Investigations Unit continues to actively examine the practices of new controllers. We started that almost immediately after we published the report and guidance. we have added a significant number of controllers to our list, and we're examining their practices with regard to cookies and tracking. We are writing to them, or have written to some of them, and we have pointed out particular issues that we think need to be addressed. So we're also looking at a kind of deeper technical examination, much more technical than we did kind of in terms of the exercise that was conducted from August to December last year. So we're looking at, you know, the functionality of cookies. We're looking at third-party requests, and we're looking at a lot more stuff that's going on under the surface. But overall, I think transparency is going to be, it is a key issue for us. It's a key issue in this exercise, and it's a key issue in data protection, I suppose, as you all already know. So controllers can certainly expect from October, expect us to be looking at enforcement action in cases where they have failed to bring their practices into compliance with our guidance and with this report and with the law. And I think with that, I will let you know that in the next slide that, as I've already mentioned, our deadline is the 5th of October, and that marks the end of the 6-month period since we published the guidance in April. And after that, controllers can be expecting to hear from us. We will be going back to examine the practices of controllers who took part in the original sweep, and we will be continuing to examine other controllers that we have written to, and that we will continue to write to, probably over months, if not years, to come. So I think with that, I will hand back to Hugh for the Q&A. I think Hugh might want to get Tony initially to answer some questions on our enforcement priorities.
Thank you both very much for that. Very, very helpful and very informative run through not only the history of the legislation, but the history of the cookie sweep to date. I suspect that one outlier out of the 40 companies approached might be now regretting that they didn't at least pick up the phone and respond to the original questionnaire. But Elaine, you finished off there with the outline and a fairly stark slide, obviously, with the deadline displayed on it, and obviously nothing focuses the mind like the knowledge that there's an impending deadline looming. But to that point you made about the enforcement mechanisms and the enforcement activities, it's one that I suppose always intrigues me and our clients. Maybe Tony, if I start with yourself, given your role within the Commission, maybe to outline what you think those priorities will be once the deadline has passed. I'm mindful that there has been a stay agreed with your office or offered by your office until the 5th of October passed. But maybe, you know, how
yes,
how
Hugh, absolutely delighted to address that issue. Yes, we are certainly going to be active. Let's put it that way. We're not setting a false deadline. So come the passing of the 5th of October, we will be re-examining not only the 40 websites that I talked about in the sweep, but the many websites that we are looking at over the last few months, as Elaine alluded to there. We are actively checking websites, taking note of their current status in terms of the cookies, actually taking down the details. We will be revisiting those websites from the 6th of October onwards to see, well, has the landscape changed? Has compliance happened in the meantime? And I'm afraid for those for whom it hasn't happened, well then trouble is looming, I'm afraid, from our office, because we are expecting that with the 6-month lead-in period, that organizations will have got their house in order. So really what we're going to be focusing on, for example, are particularly focusing on websites that the public are almost, I suppose, compelled to look at. In the first instance, I'd be talking about public sector websites, local authority websites, banking, credit unions, health insurance, media, restaurants. It's the stuff that people, it's almost like a magnet, you know. I sit down at night time when the kids are in bed, and I browse the internet, but I'm generally browsing the same almost websites every night. But then you have the situation where you're browsing because you have to access a service from a government department or a local authority, be it planning permission or be it to get a grant or anything like that, anything that you don't have any choice but to nowadays use a website to access. Those are the ones that be particularly focused of ours. But what we'll be looking at, I suppose, in terms of the priorities, Elaine mentioned there that one of the major issues is the setting of non-exempt cookies set without consent, particularly the large number of advertising trackers. That's one, particularly when we come to look at, well, what are the issues we're going to be looking at? That's going to be top of the list, as is the use of implied consent. We'll be looking obviously at the pre-checked boxes or sliders set to the on position for targeting and unnecessary cookies. Obviously the transparency issue and the accurate information, again, those are really key. We'll be mentioning also looking at anything to do with special category data. So over the coming weeks, then, we're going to, and there's not too many weeks left now, but we are spreading the net very wide in our research of the websites that's not compliant. And we're going to be, as I say, from the 6th onwards, re-examining all those. We will have our sleeves rolled up on the 6th of October to actually give meaningful effect to what we meant when we were saying we're going to do enforcement. That's what people can expect, and we wouldn't be doing the public any service if we were to do anything less. So really the message I want to be very clear on today, because it is my responsibility, I am expecting that the public will hear about the serving of enforcement notices in Q4 of 2020.
Thanks, Tony. And in terms of the tools, then you mentioned there, I suppose, outlining you know, just the optics, the immediately visible content of a website. But and I suppose ourselves included have had a bit of an education over the last 6 to 12 months in terms of the technology that's available for monitoring. Do you have particular tools in mind for monitoring the website?
Well,
evaluating
well, yes. Well, monitoring will be our own. It'll be our own. It'll be Elaine and our technology people who will be looking at it in the office in that regard. But in terms of an enforcement tools that we would have, we will be first in terms of what the law provides for us. It'll be Regulation 17.4 of the SI 336, which gives us the power to serve enforcement notices. But the other thing, and the thing to bear in mind that people need to be aware of in terms of enforcement notices, and I want to be very clear on this, they will set, the enforcement notice will set a period of, for example, 21 days. If you get if any organisation gets an enforcement notice from the Data Protection Commission, there's a requirement in it, do X, Y, and Z by the date, and the date is usually about 21 days. But if you fail to comply with that, you're then into the space of committing a criminal offence unless you've appealed the notice to the Circuit Court. So if you're an organisation that receives an enforcement notice from the Data Protection Commission, you have two choices: comply or appeal. And if you don't appeal to the Circuit Court, and that can be a long process, well then, and if you don't comply within the set period of, say, 21 days, you're then into the space of having committed a criminal offence. And if you do that, if you fail to comply and haven't appealed, well then you're into what could happen then is the Data Protection Commission, actually me, would be prosecuting you as for failing to comply with the enforcement notice, and that would be a prosecution in the district court, which could face a fine of up to €5,000, for example, for a company. The other thing to say to you about that is we're very accomplished at this stage at prosecutions, and it's something we have become very skilled at doing, and we do it in relation to the very same instrument, in fact, SI 336, in relation to electronic marketing, in relation to Regulation 13 of that, and we go to court regularly, and we would be in court again at the moment, only that the courts are not quite as open as we'd like, but we certainly make a few prosecutions every year in relation to that. So just to point out as well, supposing the situation arose that we were prosecuting an entity for non-compliance with an enforcement notice, well, we might look behind it to say, well, why haven't they complied? And just to point out that a director of a company could find themselves in some difficulty if we come to the conclusion that the reason that the enforcement notice wasn't complied with by the company was because of negligence on the part of the of a director, we could separately prosecute the director in their own personal right for their role in the committing of the offence by the company. It's just to bear that in mind that nobody wants to be. We don't do that too often, but the option is open to us, and we have done it in the past. I have prosecuted individual, for example, private investigators in their own right for actions taken by their company, because I knew that the actions were really the fault of the directors. But that's just to say that we've very strong powers, and it's also important to say now to go to the heart of what Elaine was talking about there, that in the event that we found that the use of the cookies or information derived from the cookies involved the processing of personal data, and if we saw a problem there that required us to open an inquiry, if we thought that that was warranted, well, we could use the powers that we have under the Data Protection Act 2018 and to open an inquiry in relation to an organisation, and then we'd have the full suite of GDPR enforcement tools available to us. And again, we'd be looking at everything, all the articles that would be relevant in terms of the processing of personal data. And all I'm saying to your audience today is you wouldn't want to be getting into that sort of difficulty with us if you could avoid it, because any organisation that's subject to a formal inquiry by the Data Protection Commission under the GDPR, it's a bloody uncomfortable spot to be in, not only in terms of the amount of time it's going to take, but it's going to put companies under a lot of pressure, and you could be exposed to getting this GDPR administrative fine at the end of the process. Not to mention, as I say, the embarrassment of being in our annual report. And on that regard, I should also say, if companies start to get enforcement notices from us, and that's why I'm saying to you that if companies, if we served them in the last quarter of this year, you will be reading about them, and they will be named in next year's annual report, because we do use that as a tool, a very important tool, where in the past we have served enforcement notices or served even information notices. We've listed them, and again, no organisation needs to be appearing in our annual report as having received an enforcement notice if they can avoid it, because it's going to attract all sorts of attention and reputational damage potentially. So to sum up, I suppose, to let you on with the other questions, just to sum up, my appeal to today's listeners on this particular webinar is to make sure you use the next few weeks to examine critically the use of your cookies and evaluate it against our guidance note, and to make every possible effort that you can do to voluntarily comply, because, as I say, that's what we all want. We all want this to work for the benefit of citizens who use websites. If it can be achieved voluntarily, that's exactly the space we'd like to be in. We're not fools, though, and we're not expecting 100% compliance. But for those who don't comply, as I say, our sleeves will be rolled up on the 6th of October, and you'll be hearing from us.
Fair notice, Tony. Thank you very much, and thanks for the run through of the various powers and tools that are available to the Office of the Commission, not least from the GDPR, but also in preceding legislation that will be brought to bear in the enforcement of the legislation. I'd like to go on to, as Tony kindly mentioned there, go on to a couple of the questions that have been raised. And thanks again to all of you who registered for the event and sent in questions either ahead of time or on the fly today in the course of the presentation. I'll make every effort to try and get to them in the short time we have available, but in no order of priority or sequence. Maybe Elaine, for yourself here, and considering, given what you were saying about the social media usage and the case-by-case considerations, one attendee has put in a scenario circling around Google Analytics, particularly where it's been used strictly as an analytical tool rather than as a preemptive to generate marketing. In particular, where obviously all the boxes, no pun intended, but the boxes are ticked in terms of the client has an opt-out available and visible and easy to implement, a commitment to only using the Google Analytics for a measure and evaluation of website performance and how the website is working, and no information being used for marketing purposes or being shared with third parties. How then would that be evaluated by yourselves on a for instance, situation? Would it be seen as first party, or would it be seen as third party given the Google involvement?
That it is a very interesting question, Hugh, and I mentioned there earlier that we have had follow-up conversations with some of the controllers who participated in the sweep, and I think in fact this is probably the edge case that comes up most frequently for controllers. We've been asked quite a lot about Google Analytics. So again, in conversation with our technologists, you know, as I understand it, Google Analytics can be deployed in a first party way and very strictly speaking in a first party manner, but I think that this does actually require in effect Google to be acting as a processor only, and that would require a controller processor contract to be in place to ensure that any analytics obtained from the controller were not being used for third party purposes. So I think we're going to be looking at this really on a case by case basis. It's just that I think because the controller decides to describe something as first party doesn't always necessarily mean that it is in effect third party. So there can be other issues going on. You know, if the purposes change, for example, if you decide to describe something as first party today and somebody has a rush of blood to the head in 6 months' time and decides to combine these analytics with other data that the controller might be processing, that could very well mean that it no longer is first party data. Now, again, what we've also said is in our report, analytics, in particular first-party analytics, they're probably going to be they're going to be difficult for controllers, and we understand that. It's that if you decide this is first-party and this is strictly necessary, then you're likely going to be placing it in the strictly necessary bucket. So that being the case, if somebody comes to your website, for example, or your app, and strictly necessary cookies are enabled by default at all times, how do you give them the opportunity to then opt out of the so-called first-party analytics cookies? Is it possible to opt out of them at a later stage? So I think it does say in our report that, you know, it's likely that first-party analytics cookies wouldn't be considered as a major priority for us, but they would certainly be if we discovered that a controller was doing something that turned out not to be in reality just maybe combining information, providing aggregated stats or information about how somebody was using the website. And if you go back to, for example, the Article 29 working party opinion on the cookie consent exemption, which is still valid, although it goes back to 2012, there is a fairly detailed section there on first party analytics. And, you know, again, what they say, you know, they do require consent, and we know different DPAs take a different approach to this, but you know, I think if they're to be categorized as strictly necessary and we go and interrogate them at a later stage and we say, well, actually, no, because you're combining these analytics with, for example, IP addresses, that's likely to be considered a lot more privacy intrusive than just aggregated stats, for example. So there is a line in that Article 29 opinion which mentions comprehensive anonymization mechanisms. So you will know yourself, as we all do in the DPC, that the question of comprehensive anonymization is a very, very tricky area. So again, I think we will be looking at this on a case-by-case basis, but I think should controllers initially decide that something is strictly speaking first party and they categorize it as such for the purposes of first party analytics, well then, you know, we're probably going to have to take a pragmatic approach to that, and that's really essentially what we've been saying to other controllers as well.
Okay, fair point. And you'd be open, it sounds to me then that on a case-by-case basis, you'd be open to considering then the use of or the reference to, say, an alternative legal basis like legitimate interest rather than consent, depending on how an organization was to narrate its cookie use?
Now, I will give you a very, very clear and unequivocal answer to this one, and the answer to that is no. And the reason the answer to that is no is because the deployment of cookies is subject to the special rule under the e-privacy regulations which implement the e-privacy directive in the state. So that being the case, you know, Regulation 5 and Regulation 13 of the privacy regulations are they constitute the parts of the privacy regulations that are the so-called extended material scope of the regulation of the privacy directive. So therefore they are lex specialis to the GDPR, as any lawyers in your audience there will know. This means that I think, as Tony mentioned at the outset, the rules in relation to e-privacy in this case for these special areas for cookies under Regulation 5 and for unsolicited communications under Regulation 13 apply in the first instance. And that being the case, Regulation 5 does provide that the legal basis for setting cookies or access to information on the terminal equipment or access to information already stored on the terminal equipment. The legal basis for that is only consent. So a controller may not, under any circumstances, seek to replace that requirement to get consent from users with another legal basis under the GDPR. That will not wash with us at all.
Okay, you realise I had to ask, but thanks
yeah,
very
no,
much
that's
for
fine.
thanks very much for the clarity of your answer. Moving on to some of the logistics that, as organisations improve or redraft their cookie narratives and fair processing notices, when describing the cookies on the website, is there an expectation that the website operator will list them or on the basis of first or third party cookies? Or will it simply be sufficient to name or indicate the provider?
I think you're probably talking about scenarios maybe where some controllers have maybe hundreds of different cookies involved. I think if it's possible, and if the controller, I imagine that most controllers have a list available to them of the cookies and the trackers that are deployed on their websites. So that being the case, I can't really see why it wouldn't be provided to users. I suppose, broadly speaking, I would say that if it's transparent in relation to the purposes and the main cookies deployed, it might be sufficient. But again, on a case-by-case basis, if I went in to look at a website tomorrow and there was a list of cookies deployed, but it wasn't complete, or I was finding other things that I wasn't expecting, well, then I don't think that would be sufficiently transparent, because not all users are going to know necessarily how to go and look at their browser, or how to see what a particular cookie is doing. So I think, again, that the greatest level of transparency that can be provided would be preferable for us. That means if you're listing that, we use Hotjar for X, perhaps you don't necessarily need to give the name of the cookie, but I think it would be preferable, because if somebody does know how to go into their browser to have a look at what's being deployed, and they look at something that has some random string of characters, surely they should be able to see on your website what that is, I would think. Okay,
no, fair argument. Tony mentioned towards the end of his presentation about the balance and transparency, and I think yourself, Elaine, mentioned about the ETPB website as an example, where there's an accept all, a manage my settings, and a reject all button to give balance. Now, Tony talked about nudging and the unfair practice perhaps of the language of the website nudging somebody towards an acceptance of all cookies. Where do you stand on the balance, I suppose? What constitutes an appropriate balance? We've seen, for example, websites which only offer an accept all or a manage my bookings. Would you consider that to be a sufficiently balanced option for the website visitor?
Again, I think it is going to depend on a case-by-case basis, Hugh, depending on what actual activity is going on for a controller. Yeah. So I think we have said to other controllers, and we've been asked this question, in principle, we do think that 2 buttons can probably deliver a level of transparency that would be sufficient, but that would probably be dependent on sufficient information about all the purposes of the cookies being presented to users in the first layer there. And again, I think controllers would have to take into account whether just using an accept all and manage option might in some cases constitute bundling of consent for multiple purposes if somebody clicks accept. So I think, certainly, having discussed this with our technologists, I think some would be of the view that if somebody clicks accept all, that the only cookies that should be deployed in that case should be the strictly necessary ones. But again, I think the manage options, it does offer people an additional level, I suppose, of control. But I think it will depend on a case-by-case basis, because I've seen some deployment where there are two options: accept all and manage, and they aren't really sufficiently transparent, I would think. And then I've seen others which actually appear to me to work quite well. But I think, it will probably be a decision for controllers to sit down and look at, what are we doing here? Are we deploying our interface in such a way that, we do know that controllers obviously want to get metrics, and they want to get opt in, I suppose, for the use of analytics and so on as well. But I mean, it is just the way the law is, that that consent is required for these activities and for this tracking. So I think, again, on a case-by-case basis, controllers just really need to consider what they are presenting to users, and to ensure that they're not in any way seeking to mislead people.
Understood, Elaine, thanks. And on that point, I suppose one of the things you mentioned in your presentation was about the shelf life of the or the duration and activity of the cookies. Obviously, there's much debate and discussion around the mandated 6 months as a default from your guidance. But obviously, we've all seen the websites where you could have anything up to several hundred, or even in one case I saw several thousand years of a duration. Equally balanced with the argument by several website owners that the duration and shelf life is determined by the cookie designer or builder, so to speak, not themselves, and that therefore they have no control over that decision or over the duration. How are you minded to deal with that, or to respond to those arguments?
Yeah, I think, as I understand the question, yeah, it is true that you'll see quite a lot of cookies have had ridiculously long lifespans of hundreds of years, which, we can't see any purpose for that at all. I think some Google Analytics cookies have a default of 2 years. But what that reference actually is to the actual storage of the consent cookie itself, if you know what I mean, the actual cookie that records the fact of the user having given their consent, that they be re-prompted to refresh that consent every 6 months. So I suppose, in effect, then it doesn't really matter to a degree if there are cookies, other third-party cookies there that have a lifespan of a year, because I suppose in effect you're refreshing the consent after 6 months anyway. But we wouldn't expect to see really, I think 2 years is too long in terms of a lifespan. But I do understand that obviously that lifespan is set by Google Analytics. But where a controller is recording the fact of a user's consent when they come to the browser and to the website, that specific cookie, that consent state in itself, that's what we were suggesting there, that we believe that should be prompted every 6 months, so that I suppose then the controller, in terms of its consent management platform or provider, has control over when that fires, that they can set the time limit on that themselves.
Okay, no, thanks for that clarification. That's very helpful. I am mindful of the time, so there's 2 or 3 just I think that circle back nicely to what we talked about in the presentation. So if you bear with me, please, on the extra couple of minutes, and I'd really appreciate your responses. An interesting one here was raised during the presentation. If a cookie is deployed by a search query that has been typed into a search box, so that the search itself or the content of the search triggers the deployment of the cookie, can this be considered strictly necessary since the user explicitly requested the service?
That sounds a little bit maybe more technical than I think I can answer, but I can't actually see a circumstance where a search term should fire a cookie, or why, unless a controller is looking for explicit search terms for a particular reason. And again, I think there is potential danger in that if somebody goes to a particular website and keys in a search term that might involve the disclosure of potentially special category data, for example. So if you're looking at maybe a controller, say in the insurance sector, or an information website, for example, where somebody goes in and keys in, I have a disability, where do I find information? Or how do I find information on penalty points, for example? I don't really understand why that would trigger the setting of a cookie, or how that would be described as strictly necessary, if you know what I mean, unless I need more clarity in what the question was.
Yeah, as I say, I'm trying to, I might be doing a disservice to the person who who raised the question, in which case I'm more than happy to hold my hands up, but maybe they might follow up with us separately and we can liaise with yourselves if that would be okay.
Yep, that's fine.
We've had a couple of questions, I suppose, in light of, and you very helpfully gave us the history to the cookie sweep and obviously the interaction with the original 40 companies, but equally as well, the mindfulness regarding the larger social media companies who are often get the finger pointed at them in terms of the deployment of large bulk of the cookies that are triggered or fired. So a combined question, I suppose, how many websites have been examined, or to what extent has there been further interaction with the original 40 companies involved? And equally, over and above the Irish entities who form part of your investigations and monitoring after the 5th of October, is there any particular activity between the Office of the Commissioner and the larger social media companies, the likes of Facebook, thanks to the Pixel, Google, LinkedIn, YouTube, etc.?
On our interaction with the 40 controllers, Hugh, I could say we haven't had a huge amount of interaction with the 40 controllers because we distributed the report to them, and they have obviously been given the 6 months deadline to comply. But we have engaged with some of them where they reached out to us looking for further information, or they wanted to maybe sit down and have a discussion about particular issues, technical issues, and so on. So we have had some engagement with them on that front. In relation to the other controllers that we have now begun adding to our list, I think we've kind of avoided giving a number on this, and I am reluctant to. It's a significant extra number, shall we say, but it's growing, and it's growing every day because we are adding new controllers all the time. And again, this is not a project that's going to kind of come to an end rapidly at the end of this year or anything. It's an ongoing project, and it's an ongoing compliance exercise, an ongoing enforcement activity for us. So again, I would probably defer to Tony in that regard. But again, as you know, there aren't organizations that are going to be exempt from this, shall we say. There might be other issues that might be more perhaps for our consultation and supervision side of the house, but Tony might want to give you a further answer on that, perhaps.
Yeah, that's not fine, Elaine. Yes, you're quite correct there. It's not, as you say, going to finish up this year. This is the start of a compliance exercise as we see it, and an enforcement exercise. So it will go on, and our office will have even more resources coming on stream in the next few months to manage that. So and it does apply to all equally. I mean, whether it be a small business or a large multi-tech company, all I'll say on it is the same law applies, and we will apply enforcement in the same way. And I do know from speaking to some of those large organisations, I know that they're watching and getting ready for the 5th of October in the same way as smaller companies, and I suppose that's as much as I'll say about it. But we're not going to apply any favoritism or anything like that. It will be everybody treated equally from our perspective.
Oh, I appreciate that, and thanks for the clarification. One final question. I promise this is the final question. It's genuine, and you will appreciate I had to ask it. In the year of the pandemic, given that the 6-month deadline was identified at a stage where we really didn't know how long or how effective or how all-pervasive the COVID-19 crisis was going to be, has any consideration been given to an extension of the 6-month deadline as a result of what we now know the impact of COVID, particularly with working from home and with the difficulties that organizations have had with disruption to their business models?
I suppose the answer to that is no. Is simply it. We equally as the regulator are all working from home since about the 27th of March. We simply have to do our work remotely. look at it again, being realistic. If when we come to after the deadline, there's some particular entity is on the verge of making the necessary changes, and there's some delay because of COVID. We'd be looking at it pragmatically, but it's not something that we're anticipating. We haven't in any way indicated that the deadline changes. I mean, the reality is, people have since July the 1st, 2011 to get ready, and we can't at this point say that we should move the deadline because of things that have happened over the last 6 months. So that's where we're at. But we've no intention whatsoever or of changing the deadline at this late stage.
Oh, I appreciate that, and mindful of deadlines and time management. I can only thank you both sincerely for not only your availability today, but your constructive responses and positive responses, not only to the questions, but to the clarification in your presentations. I'll hand back again to John just to wrap up and sign off. But thank you both again on behalf of all the attendees, and particularly on behalf of Sytorus.
Thanks, everybody.
Thank you, Hugh, and much appreciated. And I wish everybody good luck in the few weeks ahead.
Brilliant. And listen, so thanks to everyone for joining us today. That ran over a little bit longer than we thought, but we've got really inundated with questions there. There's still some that we think we can probably answer ourselves, so we can follow up maybe directly with everyone. And of course, this is being recorded, so everyone who registered will get a link to the URL. So again, just on behalf of Sytorus, thanks very much to Tony and Elaine, and of course our very own Hugh Jones, and of course everyone attending, and for their questions. And we hope to see you at another Sytorus webinar again.
Thank you very much, everyone. Thank you.
Here's everyone.